call this second day of regularly scheduled Real Estate Commission meeting back into session. And at this time, I'd like to turn the floor over to our Executive Director, Ms. Maxwell, while we're waiting on Commissioner Haynes to get here so we can start these proceedings. It's been brought to our attention by Mr. Flitcroft that there's something that he wants Ms. Maxwell to talk to us about.
No, I want to talk about Ms. Maxwell.
Talk about her. Okay. Okay, the floor is now given to Commissioner Flitcroft. You have the floor.
Mr. Chairman, what we need to do is to change the agenda somewhat, and I'd like to do that if everybody else agrees, and address Ms. Maxwell's compensation. I'm the head of the evaluation committee there, and for some long time, Ms. Maxwell, you look at me.
Oh, I'm sorry.
You look at me. We had agreed and stated that we were going to raise her compensation by $5,000, and the state hasn't seen fit to do that. Well, they're coming up with the number of times. July 1st, they'll start doing these things again. In addition, last meeting there, we lowered the get out of jail free card for realtors that they wanted to avoid a coming before this honorable board from 1,500 to 7,500, and the state has gotten compensation of something like $12,000. I make a motion that we tell the state that this commission is strongly in favor of raising the compensation for Miss Maxwell to $5,000. She hasn't seen a raise in a long time. She didn't work any harder because she couldn't hardly work any harder. If you worked 16, 17 hours a day, there isn't any room left for that, but she's certainly deserving of that, and that's my motion.
I have a motion by Commissioner Flitcroft that we impress upon the state in the strongest of means possible that Ms. Maxwell is deserving of a raise, and that we have generated the additional revenue to fund her $5,000 raise, and that has been seconded by Commissioner Alexander. Is there any discussion? I know there's none on this except let's get it done. And we've been trying to do this now for 2 years. We've been recommending, and we have been asking the state, and they have somehow, in their infinite wisdom, decided not to do it.
Well, and that was my question, is $5,000 enough since she hadn't gotten it for the last 2 years like she was supposed to? It's time for another one.
Janet, I'll certainly affirm any amendment you want to make.
Well, I think we need to add another $5,000 to that for the additional year she didn't get it.
Originally, we did ask for a $10,000 increase in her salary.
We haven't gotten that yet, right?
No.
I'll take that as a friendly amendment if, Mr. Alexander, you take that as a friendly second.
Well, let me address that. Ms. Maxwell, let me be sure. You've not had a raise.
Microphone.
Speaking of how long has it been? Have you ever had one since you've been hired, except what you initially came in for?
The one 6 months after I started in January of 2008.
Still, that
$5,000 raise was the only one I ever got.
And it's
I should say we got, the state. Everyone in the state got like.
I understand that,
right.
But then yes, I will take that as a friendly amendment. I'd also iterate that it says that this commission will set the salary for the executive director, hire and fire.
Mr. Northern.
If I might again ask Ms. Maxwell. Ms. Maxwell, several months ago when we had the conversation with the assistant commissioner and agreed to a compromise, so to say, are you saying that that never took place?
Correct, that never took place. I mean, the conversation, I assume, took place, but...
Yeah,
but
they didn't follow through with what they
No.
promised to do at that time?
They did not.
We have a motion on the floor, originally made for $5,000 and then amended to increase another $5,000, making it a total of us asking the state to increase Miss Maxwell's salary $10,000. And you've heard the discussion of how she has not gotten the raise that we have asked over the last couple of years. And hearing no other discussion.
Mr. Chairman,
Yes, Commissioner Austin.
my understanding, and it may be incorrect based on what Ms. Maxwell says, is that it was similar to what Mr. Northern's was, which was that the matter had been resolved several months ago. My suggestion would be that we table this matter till later in the day and see if Mr. Giannini is available to come and explain to us what the situation is with respect to the agreement that we thought was in place.
Along that line of thought, I saw Commissioner Giannini yesterday afternoon as we were leaving, and he said he was coming over here today anyway, that he was coming today. And I'd forgotten that, but I think that might be a good idea if the other commissioners think it's a good idea.
It's a good idea.
Let's just wait. We can address this later in the day.
Right. And see, and we can, I'll check and see if he's available and make sure he's going to be here, and that way we could just bring it up with him at that time and see what his explanation is, and then, if necessary, we could act at that point.
Motion to table. Talk. You got to be on the record.
Sidebar.
No sidebars around here. So,
Just
hearing
front
the-
bars.
Just make a motion to table this and let's get it on
Move
the
to table till later in the day.
Second.
All in favor say aye. Aye. Opposed no. Motion is tabled, and we'll lick his calf again later in the day. Now, the next thing, the only thing on our agenda for today is a formal hearing. TREC versus Charles E. Moore, license number 52602, docket number 1218-1194831. And to assist us and handle these proceedings today, we have Judge Ann Johnson. And at this time, I'm going to turn these proceedings over to Judge Johnson.
Thank you, Mr. Commissioner and Mr. Chair. If the parties are ready, I'm ready to begin the hearing.
I'm ready, Your Honor.
All right, thank you. This hearing is now in session. Today is June 6, 2013. As Chairman Stevenson listed, this is the case of Charles Moore, docket number 12.18-119483A. And as he said, I am Ann Johnson. I've been assigned by the Secretary of State to preside over this matter as administrative judge. In that role, I will not participate in the decision on the merits. However, I will make all rulings of law, evidence, and procedure under the authority granted me by the Administrative Procedures Act. I would ask that if you have not silenced your cell phone, would you, and members of the audience, please do that as well so that our hearing will not be interrupted. At this time, I would like to ask that the commission members introduce themselves for the record, please.
I'm David Flickcroft.
I'm Grover Collins. Isaac Northern.
Bear Stevenson.
Michelle Haynes.
Janet DeChara.
Austin McMullen.
John Grease. Wendell Alexander.
Thank you, Commissioners. Mr. Chairman, is there a quorum present?
Yes, Your Honor.
Thank you. The petitioner in this case is the state. Ms. Robin L. Ryan is present and represents the state in this matter. The respondent, according to the record, is represented by Daniel E. Brown. To my knowledge, neither the respondent nor legal counsel on his behalf is present this morning. Is there any representative, or is Mr. Moore in the audience? All right. that being the case, Ms. Ryan, do you have a motion?
Yes, Your Honor. I move for a default judgment based on the fact that he was served properly. This was continued at behest of his attorney, and they are not present here this morning. And I would like to proceed on the default hearing.
All right, thank you. What, do you have any proof of service that you'd like to present?
Well, it is part of the record, should be part of the record already. This matter was originally set in January, at which time Mr. Dan Brown asked for continuance and filed a motion to continue, and then filed his notice of hearing. There was a hearing on the continuance with another judge, and that order was granted and set for this particular date with the agreement of Mr. Dan Brown as Mr. Moore's attorney.
All right, so that was done during that pre-hearing conference?
That's correct.
All right. And do you have any green card or any other documentary evidence you'd like to present?
I do have green cards. If the court thinks it's still necessary, I'll be happy to present those. But I do know from my communications with the attorney and from his representation that indeed... I'm sorry, I wasn't planning to present that. I actually thought he was going to be here today. So.
That's perfectly fine. If you don't wish to present it,
no.
that will be fine.
I did assume, maybe perhaps incorrectly, that he would be here, but as I learned yesterday at 5 o'clock, Mr. Moore decided not to attend. That's per his attorney. And his attorney told me via email this morning that he was not attending either. I would present that as proof if the court thinks it's necessary that I did get an email acknowledging the hearing today.
Well, since the court abhors a default, I think it might be helpful if you have that available.
I do.
And if you don't, then that'll be fine.
I can tell you.
You can read that into the record?
I can read it into the record.
This is an email from whom to
From
whom?
Dan Brown to me. And at 5:07 yesterday afternoon, the email read as following. Mr. Moore has decided not to attend tomorrow's hearing before TREC. Let me know if you have any questions. From Dan Brown. I sent a response at the same time at 6:08, will you be attending? I heard back from Mr. Brown this morning at 8:16 a.m. No.
Right. Thank you, Ms. Ryan. Well, I think all of you know that my function here is to decide whether or not notice is adequate under the law. And I do find, based on the proof that Ms. Ryan has presented, that the respondent did receive adequate notice of these proceedings and chose not to attend. Next, I will turn the hearing over to the Commission to decide the petitioner's motion, whether to allow the state to proceed in default and proceed in the hearing without the respondent. Chairman Stevenson.
Thank you, Judge Johnson. Commissioners, you are fully aware of
Mr. Chairman,
the situation? Yes, Commissioner Northern.
based on the testimony from the State Counsel, it appears that the defendant as well as his counsel had notice, were aware of today's proceedings and chose not to attend. And in accordance with that, I move that they were properly noticed and that we proceed.
Second the motion to enter default.
Heard the motion by Commissioner Northern and seconded by Commissioner McMullen that we proceed in default. Any discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries unanimously.
Thank you, sir.
Judge
and
Johnson.
Commissioners, yes. Oh, thank you.
One point. I just want to alert, Your Honor, I am getting a copy printout of that email and to be entered into the record as well as part of, so that there is a printout copy as well.
All right, so
she's getting a copy of it.
we will make that Exhibit 1.
Thank you.
Okay. Thank you. The Commission has decided to hold the respondent in default and allow the state to proceed uncontested. There are a few preliminary instructions that I'm required to read into the record, so I will do that now and then allow Ms. Ryan to proceed with her proof. Members of the Commission are reminded that this hearing must comply with the Tennessee Sunshine Law, which requires that all discussions and deliberations during this hearing must be public and must take place before all parties if possible. During the hearing, the Commission sits as a jury and must consider only evidence that is introduced at this hearing and placed on the record. During the course of these proceedings, no Commission members should discuss anything concerning this case with other Commission members or anyone else except on the record during the hearing. Be especially careful during breaks and recesses. Failure to comply with this requirement could result in a reversal of the Commission's decision if the case is appealed. Now I need to say a word about conflict of interest and ex parte communications. If a Commission member has received any ex parte communication, which is a communication about this case when all parties were not present, or have other outside knowledge of any aspect of this case, that member is required to disclose such communication on the record. If you have, please indicate by responding yes. All right. I would add that this is a continuing instruction. You haven't seen the notice of hearing and charges yet, so after you see that, if you realize that there have been such communications or outside knowledge, then I wish you would please tell me at that time. Now, well, we'll talk about that later. As I mentioned earlier, the state has the burden of proof. The respondent does not have the burden to show that he is not guilty of the acts or omissions alleged. During the evidence phase of the hearing, I would ask that you ask any questions of the witnesses that you wish, but please reserve any expressions of your opinion on the evidence until after the evidence is concluded. Now I need to designate the technical record. This consists of the notice of hearing. There is a procedural order from a previous administrative judge. There is the state's witness and exhibit list. There's the state's motion to have witnesses appear by telephone. There's an order of continuance, a notice of appearance on behalf of Mr. Brown for the respondent, an transfer order from me, reiterating that the hearing is set for today, and the witness and exhibit list on behalf of the respondent. Unless there are additions, I will enter these as the technical record. Now, these are not in evidence. They're simply the pleadings and other parts of the technical record. We have one exhibit so far, which you will receive a copy of later, consisting of the email chain between the respondent's attorney and the state's attorney. Now I'd like to swear in the witnesses.
There are two other witnesses, Your Honor, but they will be appearing by telephone, so we will have to swear them in at the time of their appearance.
That will be fine. Just please remind me to do so.
Thank you.
Thank you. All right. We
have another one. Just one other.
I'm sorry, Ms. Maxwell, of course. Do you solemnly swear or affirm that the testimony you give in this hearing will be the complete truth?
Yes, I do.
Thank you. Any preliminary matters before the publication of the charges?
No.
Okay. In that case, if you'd like to pass out the notice of hearing to the commission members, we will give them time to read that and then proceed. Chairman Stevenson, please let me know when the commission's ready to proceed.
Ready, Your Honor.
Thank you. Now, after reading this notice of charges, if you had not already realized before, you may have noticed that at least some of you several years ago heard a case involving this same respondent. I need to ask you, did any information you received in hearing that case color your information or your opinion such that you would be unable to be objective in making a decision in this present case? No? All right. The commissioners responded no. In that case, I believe we're ready for an opening statement, Ms. Ryan.
Thank you. Morning. We're here this morning on a combination of 3 complaints that are outlined in the notice of hearing before you today. I would like to give you a little procedural hearing just so you understand. This matter was originally set to be heard on February 7th of this year, but on a request from Mr. Brown in a telephonic hearing, it was continued to this date. Part of that agreement and the order was that Mr. Brown would not practice, and we have no proof to show that he was practicing from February to the date today. As I said, there are 3 matters combined in this hearing. 2 of them involve loans made to the Home Realty Company, where Mr. Moore is the president. The third involves inactions by Mr. Moore, which I will explain shortly. In the 2 loan matters, the proof will show that Mr. Barber and Mr. Jackson, 2 of the complainants, made loans to the Home Realty Company, and these loans were either investments and or loans, and that the respondent provided promissory notes for those loans. The proof will show that the initial interest rate promised was 7 to 8%, and that the original promissory notes provided that these loans were secured by real property. You will hear that when notes came due in 2009, Mr. Barber sent a letter demanding full payment and was informed that the cash was not available, and a note thanking him for rolling his money over to a new promissory note, which promissory note was not approved by Mr. Barber. This new promissory note did not have a provision securing that the money owed would be secured by real property, and these changes, you will learn, were unilaterally made by Mr. Moore. Since that time, you will hear that Mr. Barber received a note stating the interest rate for this loan that was at 1.7 or 8% was now dropped to 2%, again, not in agreement by Mr. Barber. And another note stating that the November 1st, 2010 payment was to be deferred. Each of these letters sent to Mr. Barber were also sent to other friends and investors. You will learn that Mr. Barber did not agree to any of these changes or modifications. Another one of the friends and investors, and is the second complainant in this matter, Mr. Jackson. Like Mr. Barber, he and his relative and his company loaned Home Realty Company a substantial amount of money. Like Mr. Barber, you will learn he was promised 8% and that these notes would be secured by real property. You will learn that new notes in 2008 and 2009 did not have such a promise of security, and that when Mr. Jackson received the 2010 letter requesting a deferment on the payment, Mr. Jackson sent back a note denying that request and demanding the payment in full. You will hear that there are lawsuits pending for collection for some of these debts, and you will hear that there have been no attempts to secure the property by real property, as originally provided in the promissory notes. You will learn that there were no written agreements between them as far as investments, just these promissory notes. And you will learn that these promissory notes were prepared by Mr. Moore and Mr. Moore alone, with terms dictated by Mr. Moore and Mr. Moore alone, and no provisions to cancel or challenge except for a late payment. You will learn that even though there was such a provision, that no payments and after demands have been made. This brings us to the third matter. This complaint involves the failure of this respondent, Mr. Moore, to fulfill any of the judgment ordered by this commission in 2010. In that 2010 order, this commission found that Mr. Moore conducted himself in an improper, fraudulent, or dishonest manner and ordered him to pay $5,000 within 30 days of the September 14, 2010 order. This commission further ordered him to take 12 hours of continuing education, contract writing, and ethics within 12 months of that order, and ordered him to pay court costs in the amount of $1,743.75, also to be paid within 30 days of that order. You will hear that Mr. Moore appealed that order, but did not secure any order for any stay, meaning that, of course, these requirements should have been addressed in the fall of 2010. You will learn that his appeal failed, and that the Chancery Court upheld all of the terms and the findings of this commission in an order that was filed in August of this year, August 8, 2012. Proof will show, though, that once again, no terms of that 2010 order have been addressed, no payments, no court costs, no education, and no attempt to do any of the above. The proof will show further that he did not bother to answer the complaint based on these allegations that was sent to him October 11th of 2012. This state believes that all these actions of Mr. Moore are indicative of violations of 62-13-312B, making any substantial willful misrepresentation. Number 2, making promises of a character likely to influence, to persuade, or induce a person to enter into a contract or agreement when the licensee could not or did not intend to keep that promise. Number 3, pursuing a continued and flagrant course of misrepresentation or making of false promises through affiliate brokers, other persons, any medium, or advertising or otherwise. Number 5, failing within a reasonable time to account or remit any monies coming into the licensee's possession that belong to others. Number 14, violations of any provision of this chapter, any rule duly promulgated and adopted under this chapter, or the terms of any lawful order entered by this commission. And number 20, any conduct, whether of the same or of a different character from that specified, that constitutes improper, fraudulent, or dishonest dealing. And further, that we believe it's a violation of 62-13-313, which provides that a respondent must file a response within 10 days of receipt of a complaint. The state is asking to consider all of these facts today, all of these allegations today, and all these possible violations today, and then after you consider them all, you assess Mr. Moore another civil penalty, that you consider revoking his license permanently, and that you require him to pay all court costs that are involved in this matter. Thank you.
Ms. Ryan, I just had one question, just to clarify. There have been some discussions about the previous proceeding in 2010 and the resultant order that came out of that. I just want to make sure that the two complainants in this matter were not also involved in the 2010 matter.
That's correct.
Okay, so these are new charges,
These
not
are new,
ones that have already been
those two are new
adjudicated.
charges. That's
okay,
correct.
Good. I think we need to say that for the record. Thank you.
Yes, they are new charges. The only old charge is the 2010 complaint. These other two complainants are new, and new persons involved.
All right, thank you. I believe you can go ahead with your witness.
Thank you. I call Eve Maxwell.
No, I think I am.
I think you can raise it up.
Stand up.
Change chairs.
Get her a taller chair.
Just change the chair next to it taller. Oh, there you go.
Thank you. Sorry. I just,
we
I
can
didn't
see
want you
you.
to not be able to see me over the top.
State your full name for the record.
Eve M. Maxwell.
And Ms. Maxwell, what is your position with the state of Tennessee?
I'm the executive director of the Tennessee Real Estate Commission.
And as that executive director, are you familiar with both the license and complaint files of Mr. Charles E. Moore?
Oh, yes, I am.
Does he have a current and active license?
Yes, he does.
When did he renew that license?
He renewed his license this year on 12/20 of 2013, and he has a license that now runs until 3/21 of 2015.
So his license was renewed.
It was renewed. He's got license number 52602, and he renewed it a month before its expiry date. And so he renewed it. The actual payment was received on 2/20 of 2013, and that renewed his license from 3/21 of 2013 to 3/21 of 2015.
I'm sorry, I'm asking that because I was given information that his license renew date was 3/21 of 2013.
It was, but he paid a month. He actually paid his renewal 30 days prior to its expiry date. So he has a license that runs now from 3/21 of 2013 to 3/21 of 2015.
3/21.
Correct.
Okay. When was he first licensed?
He was first received his license as a real estate salesperson on 3/8 of 1965, and he received his broker's license on 3/22 of 1972.
Having said that, do your records reflect other complaints against Mr. Moore?
They do. They reflect a couple of letters of reprimand. There was a letter of reprimand on September the 3rd of 1997, and that involved misleading a complainant when he had agreed to assume a loan upon purchase and closing, and it was 2 years before he assumed the loan. On November of 1997, there was a complaint which was dismissed. In March of 2009, he had 4 uninsured affiliated licensees. And then he had the complaint in 2010 and 2 complaints in 2012.
Complaints in 2012. Well, let's review the present complaints. What was the reason complaint number 2011-02769 was filed?
2679, is that what you
Yes,
said?
uh-huh.
That complaint is George A. Jackson as the complainant and Charles E. Moore as the respondent.
And what was the reason?
And that complaint was opened. We received, TREC received a complaint on behalf of Mr. Jackson in which Mr. George A. Jackson alleged that Charles Moore took some of his money in the form of a promissory note, a loan or an investment, and was given a promissory note which he said would be secured by real estate as collateral, and that there was never any security given as collateral, that Mr. Moore, he felt, committed fraud in issuing a worthless promissory note that was not secured by the property. He was supposed to get 8% return on his investment, and he did not, and then it was dropped to 2%, and Mr. Moore would not return the money. He said he did not have the money to return.
Was a response filed to that complaint?
A response was filed to that complaint on behalf of Mr. Moore. It was filed on November the 9th of 2011. It was filed, as I say, on behalf of Mr. Moore by his attorney, who at the time was Daniel E. Brown. and in the response, Mr. Moore's attorney denied the allegations.
Did he give any explanation?
He said that he denies that he took the money on contract. He does admit that he borrowed $25,000 more than 20 years ago from this complainant, and that he had paid interest on the money. He executed a promissory note and then additional promissory notes that he repaid the money each time with a new promissory note. And that due to the economic downturn, Mr. Moore reduced the amount of interest from the 8% to the 2%, that he denied that he committed fraud and denied he engaged in a Ponzi scheme, and that was his answer.
Thank you. The other complaint, 2012-02240, when was that opened and what was the reason for that complaint? I'm sorry, 2012-00136, I apologize.
I've got like 6 files up here, so I just want to have to look through them to make sure I have the correct one. (0136). That is a complaint. There was a complaint filed by Mr. Kenneth Barber, in which he was the complainant and Mr. Charles E. Moore was the respondent. In this particular instance, Mr. Barber alleged that on April the 1st of 2004, he had invested $50,000 with Home Realty Inc. of Memphis with Charles E. Moore as president, and he received a contract and an amortization schedule at 8% interest, and it was payable monthly for 5 years, and there was a balloon payment that would be due in 5 years, which would have been April the 1st of 2009. He said that in 2009 he received a letter from Mr. Moore saying, "Thank you, that allowing us to roll over the investment, that they didn't have the money to repay the loan." And Mr. Barber wrote back and said that he does not want to reinvest his money. He needs his money for medical expenses because his wife had cancer, and that he wanted his final payment plus the 8% interest. And he never received that, as he just received information that Mr. Moore had no money to pay, and that he said some of the properties that Mr. Moore has listed are owned by Home Realty, and he has properties owned by Mr. Moore, and that the properties were supposed to secure his promissory note.
Do you know if either Mr. Moore or Mr. Jackson have ever received the monies they requested? The refund of the entire
Mr.
payment?
Barber or Mr.?
I'm sorry, Mr. Barber or Mr. Jackson?
Not to my knowledge.
Now, there's a third complaint, and that complaint is 2012-02240.
That is correct. And that is a 2240 is a complaint that was opened by the Tennessee Real Estate Commission for failure to comply with a final order. It was opened against Charles Moore and sent to him accordingly, and it was for failure to follow the final order, which was entered on the 14th day of September 2010.
And do you have a copy of that complaint?
Of the
Did you open?
Yes, I do.
Well, let me just ask you if this is a copy of it as well.
Yes, this is a copy of the information, which I have as well.
And that original hearing was in 2010, is that what you said?
That is correct. This
What-
final, oh, yes, that's
What were
correct.
the terms of the order of this commission in 2010?
In 2010, the commission ordered, adjudged, and decreed that respondent shall pay a civil penalty in the amount of $5,000 and shall pay this amount within 30 days to the Tennessee Real Estate Commission, 500 James Robertson Parkway, Nashville, Tennessee, 37217. They further ordered, adjudged, and decreed that respondent shall take 12 hours in approved education in contract writing and ethics, all of which must be completed within 3 months from the date of this order. They further order, adjudged, and decreed that respondent shall pay one half of all court costs in this matter, which was broken down as follows: the administrative law judge $800, court reporter fees $943.75, for a total of $1,743.75 in court costs, and the costs were to be paid within 30 days from the date of this order, to the same address of the Tennessee Real Estate Commission.
Was that order appealed?
That order was appealed.
And was there any stay granted, any stay of any of the terms of the order pending the appeal?
No, there was not a stay granted.
And when was the appeal finally come down? When did that appeal come down? The order from the Chancery Court?
From the Chancery Court. The order from the Chancery Court came down on August the 8th of 2012.
Let me back up a minute. When the order was entered in September of 2010, and he had 30 days to file, to pay certain monies, did he pay any of it?
No, he did not and has not.
Okay, so he didn't pay it back in 2010, and he hasn't paid it since the order came down in August of 2012?
That is correct.
Has he paid any of the court costs?
No, he has not.
Do your records reflect he's attended any of the continuing education classes as required by this commission?
No, they do not.
Okay. So it would appear that he's not done anything concerning this 2010 order?
That would appear to be correct.
Okay. What does the law provide when there's an order of this commission? Is it a violation of the law not to follow the terms of this order?
Yes, it is a violation.
Can you
of
tell
the-
me where that is in this code?
6213-312B. I don't think I brought my book up.
Would it be 14?
14.
I will have you look at that, and if you don't mind reading it for us.
Yes. (6213-312B14) states, well, let me read the beginning part of this. The Commission shall have power to refuse a license for cause or to suspend or revoke a license where it has been obtained by false representation or by fraudulent or act or conduct, or where a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of. And then number 14 states, violating any provision of this chapter, any rule duly promulgated and adopted thereunder, or the terms of any lawful order entered by the Commission.
Thank you. And again, there's no record of attempts even to follow the orders of this commission.
No, there is not.
Now, was a copy of this complaint sent to Mr. Moore for his response?
Yes, it was.
When was it sent?
It was sent on October the 11th of 2012 by certified mail, return receipt requested.
Do your records reflect that he received a copy of it via certified mail?
Yes, we have a green card that was returned, signed by J. Grisham, and that card was returned to us, as I say, signed, and shows receipt on October the 19th of 2012.
Now, that's not Mr. Moore's name, but so where was this sent?
It was sent to Charles E. Moore Home Realty Company, 3412 Park Avenue, Memphis, Tennessee, 38111.
Is that Mr. Moore's official address with the state of Tennessee?
That's his address of his firm, Home Realty, and that has been the address of his firm since, let's see, that's been the address of his firm for for about 20 years.
No changes.
No changes.
Okay, thank you. Do records reflect that he ever filed a response to that complaint?
He did not file a response to this complaint.
Thank you. Your Honor, at this point, I'd like to enter complaint number 2012-02240 as my next exhibit.
Thank you. We'll mark it as Exhibit 2.
Concerning the complaints of Mr. Jackson and Mr. Barber, does it appear that the loans that are in question were for real estate in some way?
It appears that the loans or investments were to be assigned properties as collateral on these investments or loans, and that's what it appears from the information that was given.
Were the loans to Mr. Moore individually or to a company?
From Mr.
Mr. Jackson and Mr. Barber?
They were to Mr. Moore. One of them was to Mr. Moore DBA Home Realty
Company.
And
to Mr. Moore DBA, doing business as?
Doing business as
Okay.
Home Realty Company. And then another was to Home Realty Company of Memphis by Charles Moore. So he signed on behalf of the company.
So, and I'm asking your opinion, is that the reason these complaints were opened? Because they were related to real estate or to his license? How are this, what's the connection?
They were related to real estate and investments, and done as part of the part of Mr. Moore engaging in the activities that require a real estate license.
And do you have any information to show who owns Home Realty Company?
Home Realty Company is owned by Mr. Charles E. Moore.
So the company is owned by him, and he's the president of the company as well?
That's correct.
Okay. And the loans were made to either him doing business as or to the company directly?
That is correct.
Okay. Are there direct laws concerning making loans in the name of real estate, or any actions of a licensee concerning these types of actions? What laws might apply in this matter?
Under the Broker Act.
On the Brokers Act, yes.
If under 362.13.312, if one were engaging in conduct that constitutes improper, fraudulent, or dishonest dealing, that would be a violation of 312. The allegations contained in the complaints discuss and they allege that there was fraud in the inducement and fraud during the course of the contracts, the promissory notes.
Are there laws concerning promises to pay or anything when they don't intend to pay?
Well, making any substantial or willful misrepresentation is a violation of 6213-312 as well. Making a promise of a character likely to influence, persuade, or induce a person to enter into a contract or agreement when the licensee could not or did not intend to keep such promise is likewise found in 6213-312B. That's number 2. So those are violations of the Broker Act as well.
And
Yes.
that what led your department to open the complaints in the first place?
That is correct.
Okay. Now, what law applies to filing a response to a complaint?
6213-313 requires that the accused applicant or licensee, who would be the respondent, shall within 10 days file with the Commission the applicant or licensee's answer to the complaint, a copy of which shall be transmitted to the complainant. And that's in 6213 A2.
Now, Mr. Moore did file a response to the complaints of Mr. Jackson and Mr. Barber.
That is correct, he did, through his attorney.
So there was only one time he didn't file a response?
He did not file a response to the complaint that was initiated by Trek.
This time, Your Honor, I would like to have the other 2 complaints that we spoke about entered as the next exhibits.
We will enter the complaint from Mr. Barber as Exhibit 3 and enter the complaint from Mr. Jackson as Exhibit 4. Yes. The complaint from Mr. Barber is Exhibit 3, and the one from Mr. Jackson is Exhibit 4. It was Exhibit 2. The complaint, the
notice was not an exhibit?
no.
Okay.
So far, we just have 4 exhibits, one of which you don't have yet, the email, and then the complaint regarding the, by the commission.
Was not a...
No, that's a pleading in it, no.
Okay.
I have just another question or two, Ms. Maxwell. In the agreement to continue this matter, Mr. Moore agreed not to practice real estate. Do we have any proof he did any practicings from February to the present?
No, we do not have any proof that he did.
Okay. Do we have any auditors at present that can check on those things?
We don't have any auditors who can check on those things at the present time.
I have nothing further for the witness at the moment.
Right. Commission members, do you have any questions for Ms. Maxwell? Okay.
Maxwell, would you please explain to me the process by which an individual's license is renewed after failing to conform to orders handed down in the formal hearing?
Oh, Mr. Moore still had a license that was in a renewable status. His license had not been revoked and had not been suspended. So even though there was an order against him, there was not an action that was taken that would have prevented him from renewing his license. He was grandfathered for education, and just because there's an order outstanding without a suspension or a revocation or something else that would have put him in a non-renewable status, he was in a renewable status at that time.
We just read something that if they had failed to meet everything that this commission had ordered, that they would be not renewed.
It would take coming back in like we were doing in this hearing for a final determination of whether he would be suspended or revoked, or
You don't flag them or anything anymore?
he was in problem status, but he was not. There had not been an action taken by this commission that would have put him in a position where he could not be renewed, so that there was a final order that required the payment of money and certain education, but that was not that did not put him in a non-renewable status. Had he been suspended, he would not have been in a renewable status, or if his license had been revoked, he obviously wouldn't have had a license. But there had not been an action taken by the commission that would have put him in a non-renewable status.
Just so I'm clear then, the action taken against the co-defendant in the first case would not have allowed us, would have prevented us from having to do this a second time.
I don't know if I can really answer
Co-defendant's
that
license was
question.
suspended.
No, it would drop down from a broker to affiliate broker, weren't they?
But it was suspended for a
Also
year.
suspended.
Oh, you're right, you're right.
He dropped,
Sorry.
the license was dropped from a broker to an affiliate broker, and then though his affiliate license was suspended for 1 year, and he could not retake the exam for 2 years, I believe, for a broker's license. That's basically, I just read it in the order just a few minutes ago.
There was no suspension for Charles Moore at that time.
No, there was no suspension nor revocation at the time.
That should have been up to the commission to put that in, if we could have put that in the order, though. But we didn't at the time, chose not to.
We did not for Charles Moore. We did for the other co-defendant.
Ms. Maxwell, are there any affiliates with this business?
There, currently, we have there's two affiliate licensees and one broker that are affiliated with this firm at the present time.
The firm license in Charles Moore?
The firm, he's the principal broker, and then there's another broker in the firm and two affiliate brokers in the firm.
But who has the firm license?
Firm. Oh, home. Oh, you mean the name of the firm?
No, not the name. Who owns the firm license?
Well, Charles E. Moore is the principal broker of the firm.
How is he acting as principal broker if he has an inactive license?
He has an active license.
It's in problem status.
He has
I'm sorry, I thought you said earlier it was inactive.
no, he has an active license at this time.
Who is the other broker in the firm? I don't know if that makes a difference.
There's two affiliate I'm sorry, there's no affiliate brokers. There's two brokers. One is Diana L. George, and one is Ralph Dansby, and then there's Mr. Moore, who is the principal broker.
They were all three brokers?
Yes, I'm sorry. Yes, I thought that he'd had affiliate brokers, but they're all three brokers. So there's three people in all affiliated with the firm, two of whom are just brokers, and then Mr. Moore, who is the principal broker.
How long have these two folks have their license? If it's hard to find.
No, I have it. I have it here. I just have to find it.
Broker's license is fine.
As I say, I do have it here. I'll
Judge Johnson, while
Second.
Ms. Maxwell is looking up this information, it's been requested that at some point in the not-too-distant future, at your discretion, that we would like to take a short break.
If I might address that, the next witness has to be by telephone, so we have to take a break anyway.
So can we finish with Ms. Maxwell? Okay, then we'll take a break after that.
It's really not that important, Eve. That's
They
fine.
had been,
That's all right.
I don't know why I
Ms.
can't
Maxwell.
find it.
I'm sorry.
no, here I have it. I'm sorry. I just have
Didn't
so
know if
many.
he hired them recently or if they've been with him for a
They,
long time.
Miss George has had a license since 4/30 of 1987, and she's been a broker since 9/20 of 2004. And then Mr. Dansby was first licensed as an affiliate on 10/21 of 1975, and he got his broker's license on 9/24 of 1982.
Been with this firm the entire time?
They've been with this firm a long time. I don't know if
But a
they've
long
been with it a long
time.
time. A long time.
Other questions for Ms. Maxwell? Redirect, Ms. Ryan? Right. Thank you, Ms. Maxwell. And our break should last how long?
10 minutes.
All right, so
Turn up.
we'll go ahead.
Is it done? Okay. Thank you.
We don't have all the people here.
Well,
There's a quorum.
Get him back here?
well, Bear's right there, and I think
Okay, could you ask Mr. Stevens if he can come?
Who are we missing?
John went out in the hallway.
Your Honor,
All right, we're back on the record.
thank you. If we are not able to go forward with the two witnesses by telephone, I'm going to ask that this court consider severing those two complaints, and I will move forward with the one complaint that doesn't need those two witnesses. And then they can make a determination what to do about them or not. Have you got it?
Well, when you're ready to make that motion, we can talk. I mean, certainly that would be up to you if
Okay.
you wish to do that.
Can we just skip them or move on to the next witness until she gets that one on the phone?
No, because they're both on the phone.
Okay, I'm gonna hang up now from my cell
This should,
phone. I'm gonna dial in.
We're gonna
and then
try
you
again.
Dial in, okay? All right, thank you.
Your Honor, can I ask you a question?
Go ahead.
So we're considering three separate complaints this morning, is that correct?
Yes.
So we have three separate findings of facts?
No. No, you would do it together. They've been consolidated.
Or what?
So enjoy the lovely ringing. Now,
It'll
I've given
ring
him,
until he joins into the bridge line, and then it should connect.
Arba?
Oh,
Okay, it's
Thank
a
you.
miracle. Yay.
thank you, Mr. Barber. I'm going to turn this over now to the judge who will swear you in. This is Robin Ryan speaking.
Okay.
Good morning, sir. This is Judge Johnson. The commission members are here with me. We have an audience, and of course, Ms. Robin Ryan, the attorney for the state, is here, and she will ask you some questions. Will you please raise your right hand?
Okay.
Do you solemnly swear or affirm that the testimony you give in this hearing will be the complete truth?
Yes.
Thank you, sir. Now, Ms. Ryan will ask you some questions.
Thank you, Mr. Barber. Could you please state your full name for the record?
Kenneth V. Barber,
And your address, Mr. Barber?
200 South Fairhope, Alabama.
Okay, 200 South what?
South T-double-E, like golf tee.
Okay. Okay. And how do you know Mr. Moore?
Well, I met him probably,
I can't hear you. Hello?
is that better?
Yes. How long have you known Mr. Moore?
Since probably early 80s.
Okay. And how do you know him?
Well, some mutual friend introduced us. We were investing in real estate, and
I'm sorry. And what?
that you could invest with him and get a decent interest rate.
Okay. So, did you invest with Mr. Moore? Hello? Hello?
Okay, everybody turn your microphones towards you. That's what causes feedback.
Mr. Barber?
Yes.
Did you invest with Mr. Moore?
Down, like down, you want down.
Like they're facing you.
Did you, Mr. Barber, did you invest with Mr. Moore?
Yes.
Okay. Did you invest in home realty?
Yes.
When was the first time you loaned or invested money?
I can't give you a specific date because those contracts have expired and I no longer have them in my possession, but it was about that time, I'd say the early 80s.
And did you do a recent investment in the 2000s?
I did in 2004.
And how much did you invest in 2004?
$50,000.
What was the interest rate?
8%.
Was the promissory note drafted by you or by Mr. Moore?
I'm sorry, say again?
Did Mr. Moore present and draft the promissory note to you?
Yes.
What besides the term 8%, was there a provision that your money would be secured by real property?
That was stated in the contract.
Okay. In the promissory note?
Yes.
Okay. When was the final amount of that 2004 note due?
April 1st, 2009.
On April 1st, 2009, did you get paid in full?
No.
I see a letter from you of April 13, 2009. Do you have that letter in front of you?
April 13th, is that the one, the demand letter?
It's a letter that states April 13, 2009 to a Miss Grisham at Home Realty.
Oh. Well, let's see if I have one of that. Yes, I do have that here.
Could you read that, please, for the record?
Miss Grisham, I am returning the promissory note as I do not want to reinvest this $50,000 for 5 years.
Read the whole letter, please.
Can you not hear me?
No.
Well, let me get a little closer to the speaker.
Can you read the rest of the letter?
We
We can't hear you.
Well, gee whiz. Okay, how about now?
All right, try now.
All right, I guess the speaker. I am returning the promissory note as I do not want to invest this $50,000 for 5 years. We need the money at this time for medical expenses, as my wife was diagnosed with cancer last April. Please deposit the final payment of $50,000 plus approximately 1/2 month's interest at 8% to the Schwab account that previous interest payments have been going into. If this is not suitable, mail directly to me at this address.
Did Mr. Moore pay that $50,000 to you?
No.
Did he pay 8% interest at that time?
He did for a period of time, up until October of 2010. Then he dropped the rate to 2%.
Did you agree to that?
No. I never agreed to anything except I wanted my investment back.
I see a letter to you dated November 4th of 2011. Can you read that record for me? That letter? Mm-hmm.
To me?
I'm sorry, to Mr. Moore, from you.
And what's the date?
November 4th, 2011.
Oh, okay. It says, Dear Mr. Moore, on April 2004, I invested $50,000 with Home Realty for 60 months at 8% interest, with the final payment of $50,000.56 due April 2009. In April 2009, I sent a letter requesting the final payment. I did not say I wanted to roll it over to a new contract. I received a letter thanking me for rolling the money over to a new 5-year contract. This was an arbitrary decision on your part, which I did not agree with. I have since received letters stating the difficult business environment and reducing the interest rate to 2%. In July 2011, in your office, we discussed the security of these funds. You agreed at that time to supply me with information on the real estate securing these funds and the financial status of the company. I have received nothing. Therefore, I am requesting that you comply with the terms of the original contract and return the $50,000 promptly. I will wait 10 days from your receiving this letter before I take any other action. Sincerely, Ken Barber.
Did Mr. Moore pay any of that $50,000?
No, he never responded to that.
Now, did he provide you any information at all about the financial status of the company?
Nothing.
Now, in your promissory note dated April 1st of 2004, there's do you have a copy of that document in front of you?
Yes, I do.
There's a section in it that says, this note and interest will be secured by an assignment on real estate located in Shelby County, Tennessee, and recorded in the office of the Register of Shelby County, Tennessee, within 60 days of the date above. Do you have any proof or anything to show that your promissory note was secured by real property?
No.
Are you currently involved in a lawsuit with Mr. Moore?
Yes.
What is the status of that lawsuit?
I have given a deposition. He has refused to give a deposition, and as of now, it is scheduled for hearing on July 22nd.
Oh, is that in Shelby County?
Yes.
Have you been served with any notices of any difficulties financially, that is, that there's a bankruptcy or anything pending?
No, none other than the letters about hard times and had to reduce the interest rate.
Now, Mr. Barber, on the reduction of interest rate from 8% to 2%, were you given another promissory note that outlined those terms?
He did give me another promissory note, he deleted the paragraph about secured by real estate. It did show 8% still, and I got a new amortization schedule. But that was...
I'm sorry, that was when?
That was in April 2009 when he did not pay the money back.
In 2010, when you received a letter saying the interest rate was going to be reduced to 2%, was there an additional promissory note showing that?
No, not the 2%, I don't believe.
Okay. Have you received any of your original $50,000 back?
No.
When is the last time you received a payment at all on the investment?
I am receiving monthly payments of 2% still.
Mm-hmm. So even though you demanded, though, the full amount, that's not been complied with?
I'm sorry, say again?
Even though you demanded the full amount to be refunded to you, that has not been complied with by Mr. Moore?
No.
Thank you. I have no further questions.
Thank you. Members of the board, the commission, do you have any questions for Mr. Barber?
I have a question.
Mr. Barber, one of the commission members are now going to ask some questions of you.
All right.
You've got to talk.
You've got to speak up.
Mr. Barber, are you cashing the checks for the 2% interest?
Those checks have been going for several years directly into a Schwab brokerage account, and so I guess effectively they are being cashed, although I don't endorse them personally.
Thank you.
Others?
Hello?
Yes, just a moment. They're deciding whether they have questions.
No.
Mr. Barber,
Yes.
was there ever any assignment of the real estate as referenced in the original note?
No. Not to my knowledge. I've never received anything for my...
I have one follow-up when the commission is done.
All right.
Any commissioners have any other questions of Mr. Barber?
Thank you. Mr. Barber, this is Robin Ryan again. Do you have any knowledge about whether or not Mr. Moore and or Home Realty own real estate?
Yes, I've looked on the internet, and there are several properties listed under Home Realty. There are also properties listed under Charles Moore Trustee, and some under Charles Moore jointly with his wife.
And do any of these properties reflect that they're secured by a debt owed to you?
Not to me.
Thank you. I have nothing further. Thank you, Mr. Barber. I appreciate your time today. We're going to hang up now.
Okay.
Thank you. My next witness will also be by telephone.
God help us.
That's the driver.
Remind me to deny any future motion. Testimony by telephone.
I know.
That wasn't bad. Once you figured it out, I think
But it
maybe
only took us a long time.
Yeah.
Well, and I think it's your microphone that's the problem.
I'm sure it is, although I have it turned down as far as I can turn it down.
Well, the thing is the feel free to not type what I'm saying. The speaker is coming out here, and I think somehow there's that clicking is coming from Robin talking into the microphone. And
It's some kind of feedback or something.
yeah, so I'm going to call the other witness.
so much better than what we've had in the past.
Yeah.
Oh, surely you were in the other room.
Did you?
Mr. Jackson? This is Kelly with the Tennessee Real Estate Commission. Okay. I am going to ask you to call a phone number in about 30 seconds. Can I give you that number to take down so you can testify? When you're ready, it's okay. So it's 1-877-436-2482. Actually, just give me about 187. Can you hear me? Okay. His pen quit writing. Just 82. Yeah, 877-436-2482. Okay, I'm going to hang up with you now on my cell phone. Give me about 15 seconds, okay? Okay, thank you. Mr. Jackson, are you there?
Yes, ma'am.
Okay. Thank you.
Good morning, Mr. Jackson. This is Judge Johnson. I am sitting with the Real Estate Commission, and all the commission members are present here. Also, Ms. Robin Ryan, who is an attorney for the state, is here and will ask you some questions. Before that, I need to swear you in. If you'll raise your right hand, please.
Okay.
Do you solemnly swear or affirm that the testimony you give in this hearing will be the complete truth?
I do.
Thank you, sir. Now here's Ms. Ryan.
Good morning, Mr. Jackson. Would you please state your full name for the record?
George Allen Jackson.
And your address, Mr. Jackson?
My physical home address is 2401 Meadow Ridge Drive, Memphis, Tennessee. My office is 5718 Ferguson Road, Parkman, Tennessee.
And what is your business, Mr. Jackson?
Jackson Glass Company.
And let me ask this. Who is Mary Jackson?
My ex-wife.
Okay. Did you and/or Mary Jackson and/or Jackson Glass Company invest or loan money to Home Realty Company?
Originally, when we were married, we invested together. And then after our divorce, she invested on her own. And, of course, I invested either through the company or on my own.
And when was that first investment?
Oh, back in the 70s, I guess. I would have to say somewhere maybe late 60s.
And recently have you invested?
No, I haven't.
Okay. When was the last time you invested?
Well, I had a note come due, I believe it was in 08, and Mr. Moore only paid half of it, and then he rolled over the other $25,000, and that's been still going into the second year, I think.
And was that note in 2008 secured by real property?
It was supposed to be, but Mr. Moore, he failed to put that paragraph in the contract. On the original contract, the paragraph was there, and then when he renewed the $25,000 that he didn't have the money to pay, he issued another contract for that $25,000, and he eliminated that paragraph.
Let me ask you a question, Mr. Jackson. On these promissory notes or contracts, was there anybody's signature besides Mr. Moore's on it?
No.
So it's not something you signed?
No. It was never a point of my signing a contract. He always issued the contract with his signature, and in some cases he would accompany it with a verification by a Mr. Bronner, who was his closing attorney, verifying his signature, or his daughter, who was a whatever.
Okay. Now, I see in the complaint you gave to the commission that in 2010, it looks like, you received a letter from Mr. Moore asking you to defer the 2010 payment?
I don't recall asking for a deferral on a payment. No, ma'am, I can't recall it.
Let me read this. I understand that you've not been able to download the copy of the complaint you filed. Is that right?
I have it. I found a copy in my master file. I've had a problem with my records, and I found the copy. I have it before me.
Okay, if you could look, there's a letter that you presented to us that's dated the Real Company of Memphis, October 22nd, 2010, and it's addressed to dear friends and investors.
I'm not showing that.
You can't find that letter?
No.
Okay.
Is this something that I submitted?
It was a copy of a letter that was with your complaint file, but let me go on further. Did you ever make a request for your payments to be paid in full from Mr. Moore?
Yes. When that $50,000 contract became due and payable, I requested full payment. Mr. Moore sent me a $25,000 check, and then he said he didn't have the rest of the money. I said, well, we'll do this then. You designate a piece of property I can look at and get an appraisal on. I will pay the difference, and I'll take the piece of property to cover the $25,000 and the additional money that it would take to clear that property and sign it over to me. He says, well, I can't do that. The property values are too low right now. I said, then you give me a piece of property with a lien on it, because I'm not going to stand anymore for this contract not to have any collateral attached to it. And he's tried that on another contract, and I kept telling him, and he would say, well, I have it on a master sheet, or I have it on a blanket sheet, or it's too much trouble to go downtown and file it, but we got it right here.
Have you been receiving payments recently on your loan?
Yes, on a reduced 2%.
Did you agree to the reduced 2%?
No, I never have, and I have been to Mr. Moore's office. I have complained, and he would never address the issue other than to say he just doesn't have the money. I said, then refund the principal. I can't do that. I don't have the money.
Have you filed any lawsuits against Mr. Moore?
No, I haven't, but I've contacted the FBI for two statutes that Mr. Moore, Mr. Moore has violated. One with respect to my ex-wife's age and that investment, and to the fact that he sent out those contracts eliminating the properties being attached to the contract.
Did you ever get proof that any of your loans were secured by real property?
One time back in either the late 60s or early 70s, the first contract I did with Mr. Moore was for $10,000. I got a amortization sheet. I got the contract, and I got the recorded lien on the piece of property, which made everything according to the contract, where everything was fine.
How about in your 2008 promissory note? Did you get any proof of secured that your note was secured by real property for that one?
That was part of when the problem started, and I immediately noticed that he had eliminated that paragraph from my contract. And I have been after Mr. Moore ever since because of that removal from that contract. It was the only reason I would even invest with it.
Do you know if Mr. Moore or the Home Realty Company own any real property?
Well, I went through, or I hired a real estate girl that was good at chasing down property on the computer, and yes, I found, I think it's 29 or 30, somewhere in the 30 property area that Mr. Moore has either in his name or in Home Realty or in trustee.
Thank you. I have no further questions.
Thank you. Mr. Jackson, the members of the commission may ask you some questions now.
Okay.
Mr. Jackson, with the 2% interest, have you cashed any of the checks you've gotten?
I held those checks for a year, and I told Charlie I wasn't going to cash those checks until we settled that contract. Well, he said, you better cash them before there's no money to cover them. But at that point, I started cashing them.
Thank you.
Other questions?
Mr. Jackson,
Yes.
how much money have you you said you started investing with Mr. Moore back in the 60s?
But I can't, I'm 76, and this was back 50 years ago, so it has to have been in the late 60s when I was able to come up with enough money, or the early 70s.
How much money do you figure that you have loaned Mr. Moore through the years?
Well, gosh, I don't know. It's off and on, maybe several $1,000s, but the issue I have with Mr. Moore is the fraudulent contract, not with how much money I spent with him, or how much I invested with him, or what he paid me in interest. That's not a question. It's the fraudulent contracts. I don't know how much I spent or how much I invested with him. I'm concerned about the elimination of that paragraph that makes the contracts worthless.
He has never given you any collateral.
The first contract that I had with Mr. Moore had a collateralized paragraph in it, and I had a lien on a piece of property. And I think the 900 block of Avon, as near as I can remember, it's in the record down at the assessor's office.
But since then, you have not had any collateral on any of the monies you've loaned him?
I'd have to go back through those contracts and see which ones he eliminated the paragraph from and which ones, let me see. I have one here for, what is that one? I have one here, May the 1st of 2006, for $10,000 for myself and my grandson. That is secured by the paragraph that it would be recorded at the registrar's office within 60 days. Now, I never received that lien on that piece of property. I don't know what piece of property that was supposed to cover. But on this particular contract, it says in the paragraph that it was 60 days, there would be a recorded lien, and I would get the copy, of course, has to say. I don't know at what point in time he decided to eliminate that collateral, that paragraph, but just arbitrarily he did it every time he did a renewal or something. And I remember at one point in time, I got a notice from Jackie, his secretary, that said this contract is exactly like the one that was before, except there's a difference in the dollar amount. So I never bothered either take a look at the contract at that point. But then all of a sudden, at some point, I did look at that contract and saw that that paragraph had been eliminated.
Hey, thank you, sir.
Yes, sir.
Do I have any other questions?
Yes, Mr. Chairman. Mr. Jackson,
Yes.
what did you think, or what do you think Mr. Moore did with your money when you invested with him?
Well, back in, I think it was 05 or 06. See, I was a real estate agent. In fact, I had my license with Mr. Moore at one time when I first started into the real estate business. And I saw an article in the Commercial Appeal that there was a lawsuit brought against Mr. Moore for some dealings he had with some people on a piece of property. And I began to investigate what Mr. Moore was doing, and I realized that he was investing in these subprime mortgages, and that everything clicked at that time that he had brought Mr. Bronner into his office to do the closings, and he was running what I called a subprime paper mill, and that's why I just said, I can't trust Mr. Moore to deal with him on any investments. And then he got, and my ex-wife got hooked into that because of the environment she was in with him and his friends at the temple. And they influenced her to take her savings away from her, what I feel like. She's almost 80 years old.
When you first invested with Mr. Moore, just do you recall? Did you write those checks to the real estate company or to him personally?
No, gosh, I have no idea. Not without. I would have to say that I honestly don't know.
That's a good
answer. I honestly don't know. At this point in time, it's been so long.
Did you believe initially when you invested with him that he was buying real estate with your investment?
Well, I thought so until, I was pretty close with Mr. Moore since we were both on the police department together, real estate together, and at the Shrine Temple together. And I had a full trust with Mr. Moore. But at a point in time, I just lost that trust. And I just knew that, at some point in time, I was going to suffer, and anybody that I knew that had an investment with him was going to suffer. And the subprime mortgages that Mr. Moore was dealing in is what brought him to the point, I think, of creating what I call as a fraud in the contracts. And I don't think he was putting the money into property, because he told me he spent $10,000 over this price in order to get a new Ford Thunderbird. And I said, well, if he's got that kind of money, he doesn't need mine.
Were you all in the police department together at that time?
Yeah, he still is, I think. I haven't I haven't had a communication with Mr. Moore now in a couple of years, but I was on for 14 years with the Memphis Police Reserves, and Mr. Moore went into the academy 1 year ahead of me.
Okay. Mr. Jackson, I have one more question.
Yes.
And it's a repeat of a previous question. When you first initially invested with Mr. Moore, did you believe he was buying real estate with your money?
Well, he did. He bought that piece of property around the corner from me. He said, this is the way he presented it to me. He said, I will give you, and it seemed to me like, it was the Jimmy Carter days when it was like 12 or 15%. And he said, I'll buy a piece of property around the corner from you so you can go by and see the property every time you go down the street. And that's how I was remembered that piece of property was assigned to me under under a cloud on the contract.
Thank you, Mr. Jackson.
Any other commissioners have any questions? Mr. Jackson?
Yes. Do I have any questions?
No, sir. I was just asking my fellow commissioners if they had any other questions of you, and I don't think anybody else does.
Well, keep in mind, sir, I'm sorry to keep bringing this up, but there's never any question as to the contracts, the interest paid, the amounts, how the checks were written, whatever. The contracts showed that I sent these in to you. If you will look at the contracts, you can see that at any point he arbitrarily eliminated the collateral of this contract. And, well, I have a few other things, but I'll take those up with the FBI.
Thank you, Mr. Jackson.
Thank you, Mr. Jackson. We're going to hang up now.
All right. Appreciate your time,
Thank you.
sir.
Thank you.
Yes, ma'am.
That concludes the state's proof, Your Honor.
Closing statement?
Yes. I don't know how to characterize what Mr. Moore has done. He obviously had things going where there was money going back and forth on promissory notes, not contracts. They're not signed by these parties. They are only signed by Mr. Moore. All changes were unilaterally made by Mr. Moore, including eliminations of securing those promissory notes by real estate. Demands were made on Mr. Moore saying, we're not putting up with this 2%, want our money. We're not putting up with this change, want our money, and nothing has been done. I don't know how to characterize that. Seems to me it's fraudulent. Fraud on these parties because he did this on his own. He prepared the documents, he presented the documents, and based on these people's trust with him from the past, cheated them. I don't know how to characterize what he's done with the other order of this commission. He hires attorneys to appeal it, doesn't pay pending that appeal, even though he doesn't bother to get a stay saying he doesn't have to pay or doesn't have to do this. He doesn't do that. He just does nothing. Then, when the Chancery Court rightfully says, you all were right, he does nothing again. Then he doesn't even bother to take the time to respond when that complaint was filed. And let's go on. We have a hearing scheduled in February. He has an attorney begging for more time. We gave it to him. And, you know, the night before, his attorney says, oh, he's not going to bother to show tomorrow. This is exactly the kind of person you do not want out there dealing with the public and continuing to get the trust of people like Mr. Barber and Mr. Jackson. They trusted him from years past, and he's done nothing but abuse them. How can we trust him to be an honest representative of this property type license? How can we trust him to be the kind of professional this business needs? I'm asking you to revoke his license today. I'm asking you to find that he must pay all the court costs. I'm asking for a civil penalty, but I have no doubt that he will find some way to avoid that as well. But I'm asking you for it anyway. Thank you. And before we go further, Your Honor, I do have a copy of the first exhibit for the record.
Okay. You can ask me questions.
Well, it was a technical question for Eve based on revoking his license or just suspending his license.
If you need to hear more from Ms. Maxwell, you can vote by majority vote to recall a witness.
We may be able to talk about it amongst ourselves.
But if you'd like to vote to recall a witness, you can certainly do that.
I think we can talk about it amongst ourselves. Thank you.
All right, members of the commission, I am required to read some instructions into the record, and so if you'll listen to those, I'll try to make those brief and then turn the hearing over to the chairman for your deliberations and decisions. The commission has heard the proof in this case. It is now my duty to charge you regarding the law you should follow in reaching your decision. As decision makers in this matter, you are the exclusive judges of the facts as well as the application of your statutes and rules to those facts. In reaching your decision, you must conduct open, audible deliberations before all parties and the audience in this hearing. The Administrative Procedures Act specifically requires your order to contain 4 parts. Well, really 3 parts, but I'll explain those. Number 1 is findings of fact. The state has alleged that the respondent has committed certain acts or omissions that constitute violations of state laws and regulations. As I mentioned before, the state has the burden of proof to show by a preponderance of the evidence, in other words, that it's more likely than not that the respondent committed these acts or omissions. In making your decision, you may consider the evidence in light of your own training, experience, expertise, and common sense. You must determine the credibility of each witness and the weight to give each witness's testimony. Once you have made your findings of fact and decided whether or not the respondent committed the acts or omissions alleged, you must decide if the respondent's acts or omissions constitute a violation of the state's statutes or rules as set out in the notice of charges. For each violation you find of a statute or rule, you must specifically state the facts that show that the respondent committed that violation in this case. These violations tied to the facts are conclusions of law. Third, if you decide that there has been a violation, then you should decide what disciplinary action, if any, is appropriate in accordance with the particular aspects of this case. You may consider any evidence that the parties have introduced on the issue of appropriate discipline, including whether the conduct was of a continuing nature or whether it was a one-time offense. Finally, after you've completed these 3 steps, you must formulate a policy reason for your findings and conclusions. Your policy reason states why your decision in this situation is appropriate. Any motions must be carried by a simple majority of the panel members. Ms. Ryan, do you have a proposed order?
I have proposed finding of facts and conclusion of law for them to review and use in the determination, yes.
Okay, and we'll pass those out in just a minute. Let me caution you that the proposed findings of fact and conclusions of law are simply proposals. In order to adopt those, you can use it as a guide in your deliberations, but in order to adopt those, you need to discuss and make sure that these accurately reflect your memory of the evidence and also the conclusions of law as you see them, in your opinion. Now, unless there are questions about my charge, and should you have questions as you deliberate, you're welcome to ask me. Unless there are further questions, I will allow Ms. Ryan to pass out the proposed findings and conclusions and turn the hearing over to Mr. Chairman.
I wasn't going to enter it as a, but yes, Your Honor, for you.
Well, I need it for the technical record.
Oh, okay, thank you.
And I will enter it into the technical record. Address your chair. He's in charge.
Mr. Chairman, let me make an observation. As a threshold matter, we have three separate matters to consider. And I would propose to the Commission that we deal with findings of facts in the discussion matter first, and first discuss the Jackson complaint, second the Barber complaint, and third, the failure to comply with an order. So my proposal is, and I'll put that in the form of a motion, that we address findings of facts and discuss them before we make findings of facts separately.
I think your motion says that we take them, discuss them, Jackson first, Barber second, and
And the trick order.
in the order that was handed down in the previous matter that came before us pertaining to Mr. Moore. Heard the motion. Do I hear a second?
Second.
Second by Commissioner DeSharp. Original motion made by Commissioner Flitcroft. Any discussion on the motion?
I'd like to amend it to accept all the findings of facts that we've been presenting. Accept them all. We've read testimony of every bit of it.
Now, if I might interject here, I think it would be helpful. Now, I don't think you need to read these into the record, but I think it might be helpful if you at least read them silently and discussed, was this proven? Exhibit 2 shows this, or I think it would be good to have on the record in case of an appeal that the commission actually deliberated on the evidence presented. So that's just a cautionary note. You can do what you want to, but I think it would be a stronger order if you had some deliberations on the record.
Collins, I have some questions on the finding of facts, too. So
I'd just throw that out.
Since your amendment to the motion never got a second, we're going to vote on it. Any other discussion on the original motion, which is to discuss these in the order of Jackson first, Barber second, and then discuss our order, the direct complaint and what we had agreed upon in the order back in 2000. Any other discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. So,
Mr. Chairman, I would propose that we delete finding of fact that first we take on the Jackson matter and we delete number 5 and number 6 because we haven't had any proof or sufficient proof as to Mary Jackson. We know that Mr. Jackson did testify on the telephone that he was married and divorced from Mrs. Jackson, and that she is aged and gave some money, but I just don't see.
second that motion.
Second the motion.
Well, I'd like to discuss that. There is in an exhibit a power of attorney granted by Mary to Mr. Jackson that I think would satisfy that concern.
But is that in?
Jackson exhibit. I'll have to figure out where I saw it.
That's Exhibit 4.
Got both the promissory notes for Miss Jackson in there.
Oh, I see the power of attorney.
Power attorney granted to.
I, Mary C. Jackson, hereby extend durable power of attorney to George A. Jackson to investigate Charles E. Moore Home Realty with respect to my investment to determine whether it's sufficiently collateralized. And it's notarized.
Started to invest all this money. She invested the money herself.
But he has, what she's doing is giving him the durable power of attorney
Investigate.
to investigate it.
So I think that satisfies my concern, that he can speak on her behalf as far as what we talked about today.
John, I think he could speak in her behalf. I don't think he did. He didn't identify the debts.
Well, he did say that she invested money.
Some money.
I'm uncomfortable with those two also, but I'm 5 and 6. And I want to make this as strong as possible, and I don't know if that weakens us or not, because we didn't hear from her.
I think the fact we've got the promissory notes.
But you never talked about it.
John, I don't find the power of attorney. Help me.
They're right behind the promissory notes.
in Exhibit 4,
Yes.
I haven't seen it either.
Okay, I just read it to you guys. This is what it looks like.
I see what it looks like, but I don't see it in my
It's
packet.
like halfway through, and it's at the top says June 15th, 2011.
I agree with Commissioner
Right
Flitcroft.
behind,
Even though there was power of attorney and reference to Mary's investment, I don't think there was enough detail offered to confirm the information that's in the proposed findings of fact.
I'll make one more argument. I'm not hung up on it, but the promissory notes are included, and so the detail in finding the fact, in my opinion, can be found on the promissory notes.
I would also add that in that exhibit, there is a letter dated September 10, 2008, on Home Realty Company of Memphis, Inc. letterhead, signed by Jackie Grisham, addressed to Mary C. Jackson, that says, "Dear Miss Jackson, thank you for your investment with Home Realty Company. Enclosed is your note in the amount of $80,000 along with a schedule of payments. This is your note to roll over account number 726 in the amount of $70,000 that matured September 1, 2008. Your account will remain the same, only the amount is changed to reflect the increase from $70,000 to $80,000. Seems like that would be further evidence of the fact that these promissory notes existed and they were acknowledged by Home Realty Company.
I'll accept that.
And then on the letter right behind that's the same letter with a notation on the bottom that says Mr. Moore deleted the paragraph reiterating the collateral making contracts workable. Worthless.
In all this discussion, would you repeat the original motion?
I don't think it was in the form of a motion. I think it was just an observation that I was uncomfortable with 5 and 6. I still don't think they're not nearly as strong as some of the rest, but I do have to give fair weight to John and Austin. I think they've made good argument, especially in the default situation in which exhibits have been aired, which are persuasive. I'm saying that I still am uncomfortable with items 5, finding facts 5 and 6, but I have to concede that Austin and John have made very good arguments, especially in the context of a default judgment having been granted and the introduction of exhibits which are persuasive.
Chairman,
Commissioner Grease.
I yield Commissioner McMullen.
I was just going to say, why don't we go ahead and just start working our way through these findings of fact and vote on them up, down, discuss each one in order, and see how far we can get through it.
Let's go.
With that in mind, I'd make a motion that we adopt proposed finding of fact number 1, and if it's okay with the judge, we could skip reading it since we all have it in front of us and have had a chance to look at it.
Second.
Motion made by Commissioner McMullen, second by Commissioner Grease, that we accept findings of fact number 1 as true. Any discussion? Here none. All in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I'd move that we adopt proposed finding of fact number 2.
Second.
Motion by Commissioner McMullen, second by Commissioner DeShara, that number 2 we adopt as being factual. Any discussion? Hearing none. All in favor say aye.
Aye.
Opposed, no. Motion carries unanimously.
Mr. Chairman, I move that we adopt proposed finding of fact number 3.
Second.
McMullen makes the motion. We accept number 3 as factual and adopt it. And second by Commissioner DeShara. Any discussion?
I think it's supported by the exhibit that we've been looking at, which is a copy of Mr. Jackson's complaint, and I think the copy of the promissory note is in there.
Any other comments or discussion on finding of fact number 3? Hearing none, all in favor say aye.
Aye.
All opposed, no. Motion carries.
Mr. Chairman, I move that we adopt proposed finding of fact number 4.
Second.
Motion by Commissioner McMullen, second by Commissioner DeChar, that we adopt finding of fact number 4. Any discussion on this motion?
I think a copy of that promissory note is also in our copy of the complaint that we have from Mr. Jackson.
Any other discussion or comments? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt proposed finding of fact number 5.
Motion by Mr. McMullen that we accept finding of fact number 5, and seconded by Commissioner Collins. Any discussion on this motion?
Mr. Chairman, we have discussed this some already, and I understand the fact that Ms. Jackson was not here to testify may cause concern for some. I think there is support in the documents that we have in front of us for the allegation. Ultimately, it can be decided when we get to the conclusions of law whether, how much weight to give to this, I guess. But I do believe that it is supported by the facts, and so that's why I made the motion.
Any other comments or discussion on the motion accepting number 5? Hearing nothing yet further, all in favor say aye.
Aye.
Opposed, no. Motion carries. Let the record show that Commissioner Flitcroft voted no.
Mr. Chairman, I move that we adopt proposed finding of fact number 6.
Motion by Commissioner McMullen, seconded by Commissioner Collins, that we adopt finding of fact number 6. Any discussion on this motion?
I think this is very similar to the one we just talked about, number 5.
Any other comments or discussion on the motion by Commissioner McMullen adopting finding of fact number 6 as being true? Hearing none, all in favor say aye. Opposed, no. Motion carries.
One no.
Commissioner, let the record show Commissioner Flitcroft voted no.
Mr. Chairman, I move that we adopt proposed finding of fact number 7.
Second.
Motion by Commissioner McMullen, we adopt finding of fact number 7 is in fact factual, and seconded by Commissioner DeShara. Any discussion?
Mr. Chairman, this is supported by the documents that we have in the record, as well as the testimony that we heard today from Mr. Jackson.
Any other comments or discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt proposed finding of fact number 8.
Second.
Mr. McMillan, your number 8 would relate to the second complaint by Barbara.
So if we were going to separate them?
No, I think we are separating them. I just wanted to make sure we understood that.
Yeah, we've moved. This would move on to Barber now. We have a motion and a second, Mr. Chairman.
Any other discussion or comments?
I think this one, again, is supported by the documents that we have from the Barber complaint, as well as the testimony that we heard this morning from Mr. Barber.
Any other discussion?
I'm confused because I thought we were going to look at them separately, but we're going to look at the finding of facts all together, and then we may separate them at the end?
Well, we have separated.
I think they are separated.
They're separated as we're going through here.
Okay.
Michelle, I was just making that just to make sure it was clear that we were separating them.
I believe in response to a question from Commissioner Grease, the judge said that all of these were consolidated for purposes of our consideration this morning, and so we can do all the findings of fact at one time and then the conclusions of law together instead of having to split them up.
Any other comments on the motion that we accept finding of fact number 8 is true? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt proposed finding of fact number 9.
Motion by Commissioner McMullen, second by Commissioner Collins. We adopt finding of fact number 9. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt proposed finding of fact number 10.
Commissioner McMullen and seconded by Commissioner Collins that we adopt finding of fact number 10 is true. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt proposed finding of fact number 11.
Motion made by Commissioner McMillan, second by Commissioner Collins, that we adopt finding of fact number 11 is true. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt proposed finding of fact number 12.
Commissioner McMullen makes a motion we adopt finding of fact number 12, seconded by Commissioner Collins. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt proposed finding of fact number 13.
Commissioner McMullen makes a motion we adopt finding of fact number 13, and seconded by Commissioner Collins. Any discussion?
Is that exhibit here? I just need to see that one real quick.
Exhibit 3.
Where is it in Exhibit 3? We're looking for a letter dated.
Oh, and it was in Exhibit 4 too. You're right.
Found it.
It is.
I
Yeah,
found it. Thank
it's
you.
further back.
Yeah.
Any other comments or discussion on finding of fact number 13 is being factual? We adopt. Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt proposed finding of fact number 14.
Mullen makes a motion we adopt finding of fact number 14, and it's seconded by Commissioner Collins. Any discussion or comments on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no.
Hang on, you moving too fast.
You're fine. I was just going to say, I think that it was supported by the testimony we heard today from both of the witnesses, but that was it. Did that motion carry?
Yes.
Okay. Mr. Chairman, I move that we adopt proposed finding of fact number 15.
Motion by Commissioner McMullen, second by Commissioner Collins, that we adopt finding of fact number 15 as
Mr.
factual.
Mullen?
Discussion.
No discussion, just comment. This relates to the third cause, which is the order.
That's correct.
And you intend to include, I take it, parts A, B, and C of the next paragraph.
That's right. My motion would be to adopt the entire paragraph number 15, including subparts A, B, and C.
Any comments, discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt proposed finding of fact number 16.
Second.
Motion made by Commissioner McMullen, second by Commissioner DeShara. We adopt finding of fact number 16. Any discussion? Commissioner Grease.
And the documentation for that, I've heard the testimony. Is there documentation in this?
Yeah.
Exhibit 2, I think.
There is the memorandum opinion from the Chancery Court
Got it.
in that exhibit.
Thank you.
Any other discussion, comments? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt proposed finding of fact number 17.
Motion by Commissioner McMullen and seconded by Commissioner Collins that we adopt finding of fact number 17 as being factual. Any discussion? All in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt proposed finding of fact number 18.
Motion by Commissioner McMullen, we adopt finding of fact number 18 is true, and it's been seconded by Commissioner Collins. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Now that we have gone through the findings of fact, I think that Judge Jackson told us next we are to...
Judge Johnson.
Johnson, I'm sorry, not Jackson. Johnson, I'm sorry, Miss Johnson. I gave you that gavel. Ms. Johnson. Now, which statutes have been violated in what this matter that's before us, what statutes have been violated.
Mr. Chairman, I move that we adopt proposed conclusion of law number 1.
A second.
Motion has been made by Commissioner McMullen that we adopt conclusions of law number 1.
Commissioner, does that relate to the first and second count?
My motion would have that relate to all 3 complaints that we've been looking at. And I intend to subsequently move additional conclusions of law which would address each point of that and relate those back to the specific facts that are at issue that would support the finding of a violation of each specific subsection of that statute.
You feel there's misrepresentation in failing to comply with the order or not? I see how it affects 1 and 2. I don't see how it affects number 3. He just didn't do what he's supposed to do.
I think no, I do not believe that anything with respect to the third complaint, which would be the Trek complaint, involves subpart 1 making any substantial and willful misrepresentation.
Oh, so your motion relates only to the first and second counts?
No, my motion relates to all 3 complaints because I'm saying that taken as a whole, all of his acts and conduct violate these parts of the statute.
Okay.
So, Commissioner McMullen, so I've got it clear in my mind what the intent of your motion is that included in conclusion of law number 1 is all of those 1, 2, 3, 5, 14, 20, and subsection B of 20, all of those is included in your motion?
Yes, and actually that B is actually just where the line break was for that line, so it's part of 20. So it's 1, 2, 3, 5, 14, and 20.
Everybody clear on that? Any other discussion or comments? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt proposed conclusion of law number 2.
Motion by Commissioner McMullen, second by Commissioner Collins, that we adopt conclusion of law number 2.
Discussion?
Discussion is in order.
I don't think we can support, with reference to counts 1 and 2, about making a promise likely to influence, persuade, and induce a person to enter into a contract. I'm not concerned the least bit about the interest rate going down. When you accept a check or you let the money go to your Schwab account, I mean, it wasn't part of the original transaction, but it's not a violation of the Brokers Act to be poor. It's not a violation of the Brokers Act to miss a payment. We could. I'll be accused of that from time to time. I think the fraud that I'm most concerned about is that he.
Commissioner Flitcroft.
Yeah.
The motion that we're discussing right now is pertaining to find a conclusion of law number 2, not the 2 up there, the 2 at the very bottom of the page.
The one that says additionally respondents' acts and conduct as outlined above are in violation of section 6213.313A, which has to do with failure to answer a complaint.
I'm just lost then.
Yeah, we're down at the very bottom. That's what this motion by Commissioner McMullen.
I don't think he realized that we adopted all of the ones.
The previous motion made by Commissioner
Maybe
McMullen
we ought to read them.
Goes takes into account conclusion of law number 1, which includes subsection 1, 2, 3, 5, 14, and 20. That was the motion, that previous motion that was made and passed unanimously, and then the current motion that we're acting upon and discussing is number 2 at the very bottom of the page, which he was supposed to in 10 days file with the commission the complaint, answer to the complaint, which he did not do. Any other comments or discussion on this motion by Commissioner McMullen, second by Commissioner Collins? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt the following proposed conclusion of law, that the respondent's acts and conduct that violate Section 6213.312B1 include his statements in the promissory notes that the obligations were secured by the assignment of real property, and his claim that the note to Mr. Jackson had been renewed when in fact it had not.
Second.
Motion and a second. Any discussion on this motion?
Could you restate that for me? I'm sorry.
Said that the respondent's acts and conduct that violate Section 6213.312B1 include the respondent's include the statements in the promissory notes that the obligations were secured by the assignment of real property, and the respondent's claim that the note to Mr. Jackson had been renewed when in fact it had not.
Other discussion or comments on Commissioner McMullen's motion?
I just had a question. So are you proposing a conclusion of law number 3, or are you proposing to amend number 1, subsection 1, saying making any substantial and willful misinterpretation as shown in those 2 activities that you mentioned?
This is just a new number 3. That goes back and applies the specific facts to the specific subsections.
Heard the motion. I'm glad we've got a court reporter.
Oh, no, she can't read that.
I know she can't, but I'm just saying, I'm saying we got one. We'll have a record of everybody understands the motion. All in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following conclusion of law number 4. The respondent's acts and conduct that violate Section 6213.312B2 include his execution of the promissory notes and the letter he sent promising to continue to pay interest.
Motion by Commissioner McMullen, seconded by Commissioner Collins, pertaining to subsection 2 under conclusions of law number 1. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following conclusion of law number 5. The respondent's acts and conduct that violate Section 6213.312B3 include the execution of the numerous promissory notes that are in the record that show a continued course of misrepresentations, and his letter to Mr. Jackson that the note had been renewed when in fact it had not.
Second.
Ellen makes the motion you have heard. It's been seconded by Commissioner DeShara. Any discussion?
Question.
Yeah.
Commissioner McMullen, I think I understand what you're doing. You're tying each conclusion of law back to a finding of fact. Am I correct?
That's right.
Were there any that you don't see as relevant, as needing additional backup?
I'm sorry, what was the question?
I guess what I'm asking is, can they not be summarized, or are you going to do each one individually?
I was just going to specify the facts that I thought tied each violation of 6213.312B to those specific facts that supported a finding of that violation.
All 18?
No, we only have 6, and this is the third one. It's 1, 2, 3, 5, 14, and 20.
5, 14, and 20.
I think we've been instructed to look for a causal relationship between findings of facts and conclusions of law.
Any other discussion on the...
Mr. Chairman, Commissioner McMullen, I think you referenced the fact that he signed promissory notes as an example of willful misrepresentation. Just my own sense is that when he signed those notes, he probably did it in good faith, but at some point he decided that he couldn't honor them or wouldn't honor them anymore. So
I think that may be true. However, not with respect to the provision saying that the note was secured by a lien on real property.
That part of it I'm fine with. It's just the note itself to me didn't necessarily indicate he was stealing your money up front. It just kind of worked out that way later on.
Yeah, well, but when he signed the note saying, and repeatedly signed notes saying that they were secured by a lien on real property and they weren't, to me, that's where I see the continued course of misrepresentation.
And in addition, when you got a letter from the office
with that.
staff,
I don't think you can alter an interest rate unless it's agreeable to both, or unless it was put in the note of the instrument when it was originally signed. You just can't change it without both of us parties agreeing to it.
I agree with that, but in my own mind, I don't know that there's any proof that when he first signed these notes that he planned to tell you he's going to pay 8 and then change it to 2. But I do agree that if he did say he was going to secure it by real property and didn't, and that happened over and over and over again, that's enough for me.
Any other discussion or questions of Mr. McMullen as to his line of thinking pertaining to this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following conclusion of law. The respondent's acts and conduct that violate Section 6213.312B5 include his failure to remit the monies owed when the Barber notes matured and his failure to remit the money owed under the Jackson notes when they matured.
Second.
Commissioner McMullen has made the motion you have heard, and it's been seconded by Commissioner DeShara. Discussion on this motion. Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following conclusion of law. The respondent's acts and conduct that violate Section 6213.312B14 include his failure to comply with the order entered by this commission and affirmed by the Chancery Court.
Second.
Motion by Commissioner McMullen and seconded by Commissioner Collins. Any discussion? Hearing none, all in favor say aye.
Aye.
All opposed, no. Motion carries.
Mr. Chairman, I move that we make the following conclusion of law. The respondent's acts and conduct that violate Section 6213.312B20 include his entire course of dealing with Mr. Barber, Mr. Jackson, and Miss Jackson, and his continued misrepresentations and failure to pay money that was owed.
Second.
Commissioner McMullen has made the motion you have heard. It's been seconded by Commissioner DeShara. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
one opposed, no. I don't think we've got enough to go with Mrs. Jackson, but I think we certainly have course of dealing with the other two.
Records show that Commissioner Flitcroft voted no.
Mr. Chairman, I suggest we move on to the disciplinary action phase if there are no further conclusions of law.
Do they have any other conclusions of law that they would like to bring before this commission and have it read into the record? Any motions? If not, like you say, Commissioner McMullen, now is the time, the third thing, that we move on into what disciplinary action is appropriate in this matter.
Mr. Chairman, I move that the commission revoke the license of Mr. Moore.
I'll second that.
A discussion?
I want to discuss that just a little bit.
Motion's been made by Commissioner McMullen, seconded by Commissioner DeShar, that in the disciplinary, the penalty phase, what disciplinary action is appropriate in this matter, that his license be revoked. Discussion on this motion.
Well, this came up, and if you revoke these licenses, then you lose complete control of this individual. If you suspend these licenses for a definite period of time, a lengthy period of time, then he is still part of this commission as a licensee, and it gives us, I believe, more teeth. If he does not concur with these acts, that you can come back and prosecute him again. If I'm not right, you learned attorneys, tell me that.
Ms. Ryan, is that correct? We can't ask her?
No.
Is that right, Mr. McMullen?
We can ask Judge Johnson what her opinion is.
Well, there are provisions for someone who is engaging in the practice of real estate and not licensed, and you can certainly go against those people. Now, do you all want to, I think Ms. Ryan has something to say, but I'm a little hesitant to let her do it because if you would
clarify the differences between the two, so that we.
I'm for revoking them. The only thing I'm trying to find is some meat. Because if he doesn't do those things, then the only recourse we've got now is to turn it over to the Attorney General, and we know what they're going to do. It's not just going to let it lay there.
Okay, I think since the panel seems to agree that you'd like to hear from Ms. Ryan, I would ask that it be a short legal statement and not argument at this point.
When a license is revoked, you are right in that this commission cannot pursue under the Brokers Act. If a license is revoked and someone is practicing, you still can pursue, as Ms. Johnson said, unlicensed practice. When a license is suspended, you can pursue under the Brokers Act additional penalties in addition to practicing without a license. That, as far as any other ability to do anything, it would be limited to findings of those kinds of facts in either instance. If a licensee is revoked and they practice, there are criminal actions, but this commission cannot pursue those. A licensee who is practiced when suspended could be subject to criminal actions, but this commission cannot pursue those.
Not if they're suspended?
This commission cannot pursue any criminal matter, period.
But you could pursue civil penalties.
That's it.
Yes.
Yeah,
The issue I'm raising,
I guess my thought is we've already got a $5,000 civil penalty against him, and he hasn't paid it. So
It's been
just conversation.
no,
It's not an amendment. It's not anything. Call for the question.
Yeah, and I'm not arguing with you about it. I just,
Judge, question, what's the range on counts 1 and 2? Is revocation included in the statute?
Yes.
Okay.
Now, were you asking for civil penalty ranges?
No, revocation.
Oh, no, yes, you can do that.
Question has been called on the motion, which is to revoke the license of Mr. Charles E. Moore. All in favor say aye.
Aye.
Excuse me, before you, I hate to keep interrupting.
That's okay.
The state requested a permanent revocation. Now, I don't know, under your statute, if you have the authority to do that. Most boards and commissions do not. But perhaps you do.
We believe, the Department of Commerce and Insurance believes that, yes, all the regulatory boards have the power to do a permanent revocation. Yes.
All right. So I guess my question is a clarification. Is this a simple revocation or a permanent revocation?
I'm not real sure I know what the difference is, but permanent sounds good to me.
Is that your intent of the motion? It'd be a permanent revocation, Commissioner McMullen?
That is.
We've already voted, but is everybody okay with clarification of what we just voted on?
I really would like to know, Your Honor, what the difference between revocation and permanent revocation is. To me, they are redundant. I don't know, but I guess is there some hope of being able to reinstate if you've got to...
Yes. And again, I'm not familiar specifically with your statutes. Normally, courts have said that without specific statutory authority, a board or commission can revoke a license, and then in the future, that same board or another board can either refuse to grant a new license, or they cannot, but that one board can't permanently revoke. Now, the medical board has specific authority to permanently revoke. Health-related boards do. And it may be that the regulatory boards of commerce and insurance have that authority. I'm just not aware of that. If it's revoked, then what that means, and the way that's different from a suspension, is that a person who wishes to get a license back has to start from the beginning and start all over and come back and submit an application which the commission considers. And the commission could decide, no, you're not fit to have a license because of these past actions, and say no, or they could say yes, they wanted to. Now, if you say, well, I won't say that. A permanent would be just as it sounds.
If we don't have the statutory authority to do permanent, then we could, I guess the penalty could be unenforceable.
Yes, it wouldn't make a practical difference except in the future.
I'd like a suggestion that we just leave it at revocation and let whatever in the future decides whether they want to ask to come back or not, and let it go at that, because we don't want anything to taint our decision. Just call it revocation.
I think your motion stated, Commissioner McMullen, that his license be revoked.
Leave it there.
That was my motion, and in my mind that might mean one thing, and in somebody else's mind that might mean something else. But at a minimum, it means he won't have a license now, and so that's my motion.
I second that.
And I think Judge Johnson, if possible, I think Ms. Ryan, if she could, she's been researching our statute.
I will tell you that as far as a court goes, and this is not as the commission, revocation of license by court and reinstatement, this is a court. Whenever any partner, partnership, company, firm, or corporation claiming to have been injured or damaged by the gross negligent incompetency, fraud, dishonesty, or misconduct on the part of any licensee following the calling or engaging in the business herein described, files suit upon such claim against such licensee in any court of record in this state and recovers judgment thereon, such court may, as a part of its judgment or decree in such cases, deem it a proper case in which to revoke the certificate license granted, and such certificate shall not be reissued to such licensee except upon the consenting vote of 6 members of the commission in favor of this reissuance. In your statute, this is the only section talking about reinstatement after revocation. It's my belief that in the regulatory boards generally, but that's what I've been told, I do not have the section to quote to you that you can do a permanent, but that is my belief, my understanding internally.
Now, if you should vote to permanently revoke, and it turns out you don't have the authority to do that, all that would mean, it would not taint your entire order or your entire decision. What that would mean is that a future board, should this person reapply, a future board could vote to grant a license.
6 votes, it said.
Well, but that's a court, and that's a different situation. It's not the same.
I saw it was making reference to our commission, but it was not.
No.
Okay, I'm sorry.
Okay, so that's my motion, Mr. Chairman.
That's what we voted on, so. Yeah, we already
Okay.
voted on it.
So that motion carried?
Yes.
Is that right? Okay.
Yes.
Mr. Chairman, are we ready to move on to the policy reason?
Yes, Commissioner McMullen.
Mr. Chairman, I move that we adopt the following policy reason for our decision. This commission is charged with the duty to regulate the practice of real estate in the state of Tennessee and to protect the citizens of this state. It is in the best interest of the citizens of Tennessee and their welfare that those having real estate licenses engage in proper dealing with the public. This proper dealing is codified in Tennessee Code Annotated Section 62-13-312. Mr. Moore violated several sections of that statute, and based on his continuing violations and failure to abide by a prior order of this commission, it's proper that his license be revoked.
Heard the motion that has been read into the record reflecting our policy statement in this matter, and it's been seconded by Commissioner Flitcroft. Any comments on the motion in the second?
Mr. Chairman.
Commissioner Grease.
Commissioner McMullen, do you have other penalties that you're going to suggest, or is this conclusion?
That was all I was going to suggest. You're certainly welcome to
We've got
suggest more.
We've got court costs, perhaps. I don't know. I don't want to put anything in front of. I like your policy statement, but I think it should apply to additional sanctions by this.
Well, why don't you go ahead and vote on that? Then you'll have your policy statement, and then you can go back and amend your disciplinary action section.
Thank you, Judge Johnson. Any other comments or discussion on this policy statement? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Commissioner Grease, it's some matter that you would like?
I would like to suggest an additional disciplinary action by this commission, and that being that all court costs be assigned to the respondent.
Second the motion.
Commissioner Grease has made a motion that in this matter, that all the court costs in this matter be assessed to Mr. Moore, and it's been second. Discussion. Commissioner Flitcroft.
And that includes the court reporter's fees, the judge's fees, and any other costs involved.
Yes,
Any ancillary costs associated with this hearing.
Now, all the costs associated with this hearing, and that motion was seconded by Commissioner McMullen. Any other comments or discussion on this motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. Is there anything else that any of the commissioners have to bring before the rest of us in this matter?
In this matter, Mr. Maxwell, I think we've got a firm that doesn't have a principal broker. Do we need to send a letter of instruction to them? They've got 3 brokers, but
Practicality, they're just probably going to get one of those brokers to be principal broker
do
and
we need
still
to send a
operate.
letter of instruction to them, or?
I guess we would send notice to certainly to the brokers who are currently there. And
Or to the firm.
But the firm and there are other brokers affiliated with the firm as well, 2 other ones. So we would put the firm in problem status and then put those individuals in problem status and then send them a letter that tells them that they need to find a new firm with which to do business, or one of those needs to take over the current firm as principal broker.
Someone needs to be designated a principal broker then.
Correct, or the firm needs to be closed, whichever.
Under these hearings, do we have the ability to revoke that firm license?
There's no complaint filed against the firm.
No. Okay. Anything else? Hearing nothing, then Judge Johnson, I'm turning this back to you.
All right. Ms. Ryan, since you have to write the order, do you have any questions, clarification needed?
No, I hope to get it all from the court reporter. Thank
Okay.
you.
I would like to commend the commission. This is one of the best jobs I've seen as far as tying the violations to the facts of the case, and I know that was laborious to go through that. I have seen cases overturned when you have the facts and then you have the law violated, and it's hard to figure out. The court has said they will not make those connections, and so it was overturned because the connections were not were not made. And I'd like to commend you on your work, your hard work in doing that. And if there's nothing further, this hearing is adjourned.
Thank you, Judge Johnson.
Thank you, Judge.
At this time, I know this was all that was on our agenda. We were going to, I know Commissioner McMullen earlier voted to table the issue pertaining to Ms. Maxwell's salary increase. And have you had a chance to talk to Commissioner Giannini? Right, he told me that he was going to stop by, but we haven't seen him. We haven't had any communication with him. You know, what's your pleasure as far as doing this? Do we want to put this on the agenda for next month and request Commissioner Giannini to come and address us?
Mr. Chairman,
Commissioner
I'd like
Alexander.
to remove in the proper channels, remove the motion from the table, bring it up for discussion, and that we go ahead and fulfill our request and for Ms. Maxwell's increase in salary. Not only the $5,000 was recommended, but why the other $5,000 that was promised to her has not been paid. And I would ask that you, as chairman, request that Commissioner Giannini appear before this commission next month, either he or Commissioner Mychek, which where the buck stops, I think, to give us reasons why what they agreed to do on the previous raise has not been fulfilled. And that's my motion.
And I'll second that.
A motion by Commissioner Alexander. You've heard it. You understand it. Commissioner DeShara has seconded it. Any discussion?
So is the motion to discuss it next month and to request that they be present to talk about it? Is
that's right. But
okay.
The formal request, Commissioner McMullen, is they tell us why she had not gotten the raise that was negotiated that she's never gotten. We also then have a request for an additional $5,000, which will make it a $10,000 raise. And if they can't, and I'd like to have an answer why they can't and why it hasn't been done, and especially the first $5. You know, if you make a commitment, you ought to honor it.
So is the motion to go ahead and approve an additional $5 as well?
Yes.
Okay.
Yes. Motion. Any other discussion or comments? Hearing none, all in favor say aye.
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 Opposed, no.
No.
Commissioner McMullen votes no. I will get in touch with Commissioner Giannini and ask that he come before, based on his schedule. We'll put it in our agenda for our July meeting to have him come, either here, Commissioner Mychak, come and appear. Because our statute truly, I mean, it specifically says that the commission sets the salary for, there's certain parameters, being a state employee, that our executive director falls under. We don't have total autonomy, but it's my understanding that a raise was approved for Ms. Maxwell and it has never come forth. It's never been given to her. Anything else to come before this commission meeting? Else? Any commissioner reports? Anybody got anything to say? Commissioner Alexander? Parlor? Commissioner Grease?
No report.
Wendell's saying something to Commissioner Northern.
Yes, sir.
Next month, unless you've been replaced.
I will definitely be here if I've not been replaced. And given that discussion about the increase in our director's salary took place with me, if you want to subpoena me, I'll come in.
And Madam Chairman, if you're not here next month, it's been nice serving with you also.
Vice Chair.
Mr. Grease?
Well, then I assume you're going to be here.
Lord willing and the creek don't rise.
Commissioner Northern, Commissioner Haynes, it's been a pleasure, and I do hope to see you back next month, but just in case you're not, good luck to you, and come back and visit us sometimes.
I appreciate the opportunity that I've had to continue out the unexpired term that I've been serving, and hope to have the opportunity to continue to serve. It's been a pleasure to get to know you all and the many members of the profession that I've also met. And Isaac, I know you're going to be term limited, so your term will end, and if we don't see you here again next month, it has been a pleasure to work with you and to get to know you, and hope to see you again soon.
Thank you.
Mr. McMullen, you better be here next month. We have another hearing.
Talk
To
to the
Mr.
governor.
Northern.
And I kind of would like to say the same thing. I have had a pleasure of filling out an unexpired term, and hopefully I will be back to have an appointed term. I would like to, and I think I've made it clear to the folks that need to make it clear to, and I've enjoyed serving with everybody on this commission, as some of you have known for, long time. So some of you are new friends, but thank you.
Mr. Flitcroft?
Again, Isaac, Michelle, you've been great. And as I understand the rule, if your successor is not appointed, you get to come anyway. And I'm calling on all you folks to help me with this unauthorized practice. I need your help. Thank you.
Mr. Collins, as you're making your way back up here, we're in Commissioner reports. We're in Commissioner reports. Is there anything you'd like to say before we adjourn?
Thank you for waiting. Me and Isaac had to give us a ride back to the hotel so we could clock out. I've had a wonderful meeting, and fellowship has been wonderful. I'm going to miss Isaac and anybody else that doesn't get reappointed, including Austin or Michelle. And we've had a lovely meeting, and this is a great profession, and I hope Eve gets a raise, and Judge Johnson's been great, and all y'all have been nice to us. Have a good day.
I would like to say that I have enjoyed, and I told Isaac, I don't know, sometime earlier during this proceeding, I looked over at him and I said, Isaac, I am going to miss you, and I am. For 9 years, I have been coming to these commission meetings, and a friendship has been developed and forged, and we're going to miss you. We don't really realize just how much we're going to miss you next month. And I hope that the governor and all of his wisdom appoints us somebody that is as good as you. That's all I got to say.
Just lets him
If I
continue.
count right.
He can't. Statutorily, he can't.
But if they don't appoint somebody.
Yeah, he'll be here if he don't appoint
If I
somebody.
count right, that means you out of here next year.
Yeah, y'all won't miss me. You'll be glad to see me gone.
I remember Isaac came, he had black hair. And Barrett didn't have any.
Yeah, 10 years ago. He's got that picture. But anyway, Michelle, I have enjoyed serving with you, and hopefully you can get this appointment. And I hope, like the devil, that the governor and all of his infinite wisdom will extend a 5-year appointment to you, Commissioner McMullen. That's all I hope and pray, because you have been a valuable asset to this commission. It's been a good meeting. Judge Johnson, again, thank you for your assistance, your kind words about this commission. And if there is no other business to come before this meeting,
You lost your gavel.
I don't have my gavel, but I'll just hit my hand. It is adjourned. Meeting is adjourned.